For joining us today for the ELVIS Act Explained, how Tennessee is pioneering AI regulation for artists, part of the Tennessee Film and Entertainment webinar series hosted by the Arts and Business Council of Greater Nashville and supported by the Tennessee Entertainment Commission. I want to remind everyone that this session is being recorded, and we will share a link to that recording via email next week once the video has been processed. All right, and with that, welcome again. My name is Jonathan Harwell-Dye. I'm the Director of Programs for the Arts and Business Council of Greater Nashville. We are an independent 501c3 nonprofit that leverages and unites the unique resources of the arts and business communities to create a thriving, sustainable, creative culture in Nashville. We do this by providing education, resources, and opportunities for the creative community, and by connecting the business community to the arts to foster workplace creativity and innovation. When you become a member of the Arts and Business Council, you join art lovers, creative organizations, and leading Nashville area businesses in cultivating the creative community. You can follow the link in the chat to learn more about membership at ABC. Our flagship program is the Volunteer Lawyers and Professionals for the Arts, a referral service providing pro bono legal assistance to income-qualified artists and arts organizations in Tennessee. PLPA hosts a monthly virtual Black-owned small business and nonprofit legal clinic with our partners at the Bradley Law Firm. Tennessee small businesses that are at least 51% Black-owned with less than $1 million in annual revenue and 10 or fewer employees are eligible. PLPA services also include quarterly pro bono legal clinics for artists, musicians, and creatives. Our next in-person clinic will be held on August 7th, and registration is open now. You'll want to note, though, that you will be required to provide proof of income to qualify for free legal assistance through VLPA. If you're an independent filmmaker or documentarian living and working in Tennessee, wondering how to fund your next film or documentary project, we can help. Arts and Business Council's fiscal sponsorship program supports independent filmmakers and documentarians by providing essential support for film and documentary projects. Learn more at the link in the chat. And with that, I'm excited to introduce today's panelist. Mitch Glazier is the chairman and CEO of the Recording Industry Association of America, RIAA, and he serves on multiple boards, including Musicians on Call, IFPI, Leadership Music, and Sound Exchange. With over 20 years of experience in shaping the music ecosystem and in pivotal legislation like the Music Modernization Act and the ELVIS Act. Bart Herbison is the executive director of the Nashville Songwriters Association International, a leading not-for-profit trade organization for songwriters with a career spanning commercial radio, journalism, and legislative advocacy. Highlighted by his pivotal role in the Music Modernization Act, the acquisition of the Bluebird Cafe, and numerous accolades for his contributions to the songwriting community. And David Hodges, a multi-platinum Grammy and BMI award-winning songwriter and record producer from Little Rock, Arkansas, co-founded Evanescence and has written hits for over 2 decades, including Bring Me to Life, My Immortal, and 1,000 Years, with more than 100 million records sold and a career marked by collaborations with artists like Ed Sheeran, Christina Perri, and Kelly Clarkson, alongside significant advocacy work in the music industry. Everyone join me in welcoming our panelists to the virtual stage. All right, welcome everybody. I know Mitch and Bart, you've joined us today to talk specifics about the legislation. David, thank you for joining us to give us that creator's perspective. We really appreciate it. And I'm just going to kind of jump in at the beginning and, talk about what is the ELVIS Act. I know it's an acronym, ELVIS. It stands for Ensuring Likeness, Voice, and Image Security Act. And so, what is this act and why was it important for Tennessee to pass this landmark legislation?
Well, I can sort of give an overview of what it is. For years and years, there have been these laws called rights of publicity in the states. There's no federal law on it, but what it means basically is you have a right to yourself. You have a right to your own image, to your own name, to your own likeness. And for years, it mostly focused on false endorsements. sort of like what just happened with OpenAI and Scarlett Johansson. A company reaches out to somebody and says, hey, would you endorse my product? And the person says, no, thanks. And they imitate their voice and pretend that they're endorsing it anyway. And that causes a right of action. And Tennessee has always had a very strong right of publicity law, including for voice, but it was sort of limited because it was written 50 years ago. And it was actually written in many ways because of the need of the ELVIS estate based in Memphis to be able to protect itself. There were false endorsements all over the place. Well, all of a sudden, fake Drake happens and AI enters the fray, where now you can scrape the internet for someone's voice, copy it, and then synthetically reproduce it using their own DNA, basically. And it has nothing to do with a false endorsement. It's just a use that the artist didn't approve. Could hurt their reputation. Doesn't necessarily need to cause consumer confusion. You know it's fake, but you listen to it anyway. It can dilute the art of the artist. You can put the artist's voice on something that they've never intended, that sort of perverts their art, or make them say something that they didn't mean to say or that they don't mean. And so Tennessee looked at this and said, I think we need to update our laws in order to protect against this, specifically for AI. And no state had ever done that before. So Tennessee was the first to jump out there because of the many creators in Tennessee and say, we've got this law, but it's not fit for purpose. It's 50 years later. Let's update it for the times.
I would, look, we've got to really acknowledge Mitch Glazier and his leadership. You had to start somewhere. We had to put some guardrails around this. So there was also a strategic, tactical, political decision to do that in Tennessee. And I think your question was, why was it important to pass it in Tennessee? I posit that every form of popular music that is commerce today either had its origin roots or its commercial roots in this state. You take pop, rock, soul, R&B that turned into hip hop out of Memphis. Everybody from W.C. Handy, who was there, to Elvis, Stax Records, to WDIA radio. Country evolved from Jimmy Rogers in Bristol, Tennessee, and the hills, as well as gospel did. And then country and gospel, now modern Christian music, their commercial center is Tennessee, Franklin, Tennessee. So we should have done it. And it's part of our history. It's, Jonathan, it's part of our culture, and it's a huge part of our economy. You know, this is a multi-billion-dollar industry just to the state of Tennessee. And I think it was also important that we ensured we were going to pass this. And Mitch was very strategic. You started about a little more than a year ago involving us. And we got other questions about, you know, the unanimity of all this, but it was very strategic. And we also need to shout out to the Recording Academy. They brought members from all across this state and outside, their legislative guy, Todd Dupler. So a huge credit goes to the Brain Trust, starting with Mitch Glazier.
Thank you, Mitch. Thank you, Bart. I appreciate that. And David, I want to come to you and kind of look at it from the creator's perspective. You know, from your experience, can you talk about some of the concerns you're hearing in the writer's room from other songwriters and artists about AI? And I know you even testified about this legislation specifically. Can you talk about the concerns from artists?
Yeah, I mean, like Mitch had said earlier, the curation of an album, of someone's life's body of work for an artist, like that is so integral in the presentation of who they are to the world. So the idea that their voice can be thrown around on songs that they didn't write. There was a Christian artist that was actually at the hearing with me, and she was saying, like, because of my faith, I would hate for my voice to be used on songs that go against the tradition that I believe in. But even beyond that, as an artist, the music that you put out into the world, even if some people listening to it know that it's fake and others don't, like, there would need to be some protection of, like, an artist has spent their entire life with the help of a record label and producers and managers and others involved, to say, this is who I am through my art, and for that to be thrown around really does seem like it undoes so much of the hard work to get to that place, especially if it's a successful artist like a Drake or someone who's really built that brand up.
Jonathan, let me add one more thing before we move to the next question. I think you have to understand what the past quarter century has been like for American songwriters. Why is it important in Tennessee? This is the last songwriter community. There used to be a lot of commercial songwriter communities in this country, and it's basically now boiled down to Los Angeles and Nashville. And so I'm the oldest person on this webinar today, but early 2000s, here came piracy. And again, Mitch Glazier and the RIAA are to be credited with trying to tackle an almost unsolvable problem. It was hard to fight free. And when I took this job 27 years ago, there were several thousand signed songwriters making a decent, comfortable mid-level income in Nashville. That at one point went down to a few hundred. We went from about 40 individual record companies to now down to 5. The minute we start to get a little bit of a hold on piracy, here comes streaming. And we are still fighting laws where neither the artist nor the songwriter get compensated fairly on streaming. You may have seen we're back at it with Spotify when we thought we were sort of putting this in our rearview mirror and trying to figure out how to work together. But it's hard to, you know, when he co-writes a song, David, and there's music publishers involved, he gets a quarter of the earnings. It's hard when 35 million streams paid that songwriter less than $1,000. And when we sort of come to terms with that, here comes AI. And David, I'm going to ask you a question, if I may. It was panic in the songwriter rooms, and it still is to some degree, because what is this now? This is the game if we don't put guardrails around it, right?
Oh, it totally is. Yeah. I mean, there's when Evanescence got signed 25 years ago, almost 25 years ago now, it was right when Napster was rolling out. And I remember thinking at the time, what a tricky bump in the road. But once we figure this out, we should be smooth sailing from here on out. And I feel like every stage of my career for 25 years, it goes from one thing to the next. And AI does seem to be the next hurdle to figure out. Also presents certain opportunities.
Yeah.
There is something, I don't know, it almost feels like a widget or a game where we finish writing a song and someone in the session says, oh, I wonder what it would sound like if Justin Bieber sang on the vocal of this. Sure, that may be like fun or interesting, but if that's the kind of thing that erodes away our ability to be compensated for our work, or again dilutes the marketplace, like there's real dangers out there if we don't put correct guardrails around to help out the process.
Well, and David, you bring up a really good point, because there's a lot of sort of negative aspects of AI and how it can be utilized. But also it is a big opportunity. And I know, creators may use AI in certain different ways. And I don't know if that's changed, or if you've seen that, or if that's a topic of conversation too. Like, is there a benefit to this at all for creators and for songwriters? Or is it something that, really is just a danger that needs to be handled? What's your take on that?
I mean, it definitely is a mixed bag. We've been having a thesaurus or a rhyming dictionary in writing rooms for the last 50 years, and those are valuable resources to us. I don't think when I look at a thesaurus, is that a culmination of stealing, ingesting older poets and using their works to build this. The tricky thing about the way that AI is structured is it needs our work for those models to be useful at all, and we didn't sign up to that part of the process. So yeah, songwriters will always be using whatever tools are available to us to try to tell the most compelling works. And sometimes I think especially young songwriters don't realize, oh, these models that are helping us write a second verse, it's helping us write a second verse because it's using the works of those before us without getting permission for that. So if we can find a structure that gives the right kind of credit where credit is due, and that permission process works correctly, then I'm excited about the future of AI. I just think America has this tradition of we're so excited about the new technology that often we jump into it and then we go, oh, we probably need to figure out what to do with all this on the backside, which makes me nervous as a storyteller, as a songwriter.
Yeah, it does seem like with a lot of these technological advances, especially the ones we're talking about here with streaming and piracy, it seems like it's a whack-a-mole in a sense of like, oh, we thought we solved this, and then this new thing pops up. It's a new technology, and it just enters the marketplace before it's ever regulated, and then you kind of have to deal with the repercussions of that.
Mm-hmm.
And in terms of AI, it's not just writing the songs, but it's also the deep fakes. And so I guess my question in this is, what are the measures for the ELVIS Act? What does it put in place as far as how to enforce its provisions? And how effective do you think these measures will be in preventing unauthorized use or likenesses? Like, how effective are these, and what are the provisions? Like, what is the recourse for an artist?
Yeah, so the ELVIS Act basically gives three arrows in the artist's quiver. The first is it actually allows you to go after these voice clones or image clones, where, as David said, they basically scrape the internet for the artist's voice or image to train their models. They didn't ask permission to do it. They just did it. And it's not a copyright case. There is a complementary set of cases that we are bringing to enforce copyright law on the songwriter side with the Anthropic case where they stole lyrics to train their model, on the recording side this week against Suno and Udio for stealing recorded music to train their model. But these voice clones and these image clones, they steal voices and images to train their models. And the ELVIS Act is the first act in the country that broadly says you, the artist, have a right of action to go against the model maker for stealing your voice and your image to train their model. And you can see it if you go to any of these services, and a lot of them very shrewdly, these people are not dumb, they let the public, right, different computer programmers upload onto their platforms their own voice clones where they're the ones that did the scraping, because what they want to do, of course, is get investors so they can make money and offload the liability to kids sitting in their parents' basements, right? That's what they're trying to do. And the ELVIS Act says not so fast. You're not just going to force us to go after the kids, right? Which is what a lot of tech companies did for a long time under the DMCA and everything else. We're going to go after you for producing the model itself. That was a huge deal. The second thing is it allows the artist to go after the distributor. So if you are distributing a fake, then the artist can go after you, both to stop the distribution and for damages. And then, finally, it lets you, it gives you the ability to go after the users themselves, right? The people who are knowingly using these tools and then trying to make them go viral or to monetize them. So it's a very, very broad, effective act, broad in scope, but sort of strategic in its application. And I think the real benefit is that these companies now, because they know that they can be liable, will respond to a notice. So when the record company or the publisher or the artist themselves send a notice and say, hey, you better take this down, they know they better take it down, because if they don't, they could be liable. And that's the key here. The goal is not to force artists to bring lawsuits every day in the state of Tennessee, right? It's that you could. And therefore, when you say take it down, they take it down immediately and you can stop the damage. That's the real strength, I think, of the ELVIS Act.
And there were language changes. Look, Elvis Presley Enterprises and other artists in Tennessee are able to go to local civil courts, Jonathan. Because when you go, if somebody infringes on one of David's songs, he's got to go to federal court. You're looking at $100,000 to walk in the door. It's just cost prohibitive. The rules are not in favor of the creator. And I believe local courts are much more efficient. They're much more practical. And it makes that crystal clear that you can do that. You can go to a civil court here. And as Mitch said, the threat of it typically is going to solve the problem. But if not, get ready for civil damages till you take it down. I'll say it this way. I don't care if you're some big music artist or movie star. Any citizen of this world owns their face. They own their voice. And if you saw that somewhere being used without your permission, it's just.
Yeah. And, you know, one thing I'll say about the lobbying for the ELVIS Act that was so amazing, and it followed on the Music Modernization Act that was done in Congress a few years ago. Bart and his team, tons of songwriters, many of whom are not the voice and not the face, still went on to Capitol Hill in Nashville and lobbied to get this thing passed. And the reason why is because, you know, writers fighting for artists, artists fighting for writers, because it is one ecosystem. There really was this one for all for one sort of not just strategy, but real genuine caring about the whole ecosystem and the whole Tennessee music community and all parts of the Tennessee music community. There were people from Bristol, people from Nashville, people from Memphis, people from Clarksville. It was really heartening. I don't know that I've been through a lot of lobbying wars and a lot of fights. I can't remember one where I felt so inspired by the way people showed up for each other, which I know is Tennessee, and you know I live in Washington D.C. where that doesn't happen very often. But what an amazing display of a community coming together. And the one other thing that I would say is that the ELVIS Act is broad. It doesn't just apply to songwriters and artists and others. It applies to everybody, and I know that was very important. Child protection groups came and joined us in the fight because people take, you know, high school girls' faces and they put them on, you know, bodies that are not theirs, that exploit them sexually, and that's covered by the bill. So the idea was that Tennessee was basically saying AI is not allowed to steal your humanity, and we're going to be the first to bring you a direct cause of action to stop that. And the head of NCOSI, which is the big child protection group that helps to protect kids online from sexual exploitation, showed up at the signing ceremony and walked up to the governor with tears in his eyes and said, "I just want to thank you. Nobody's been able to do this before." It was the musicians and the artists who got together to make this happen for us. We weren't able to do it before. So that was pretty cool.
And I will add a question you had sent before. Maybe you're going to ask this anyway. Most of the things Mitch and I deal with are in the judiciary committees in Congress and on the state level. With respect, that committee is there to mess with the other side. It's email servers. It's January 6th. I don't care what your politics are. It's divisive by its nature. But going back to the Music Modernization Act, you could not have had two more polar opposite members than Hakeem Jeffries and Doug Collins, and it passed unanimously. When our legislation passed the MMA through those committees unanimously, I knew it was going to pass the House and Senate, and the same thing happened in Tennessee because music is that instrument. We all love it. It's not controversial. And this is one of the few things in modern politics both sides can come together to agree on.
And kudos to Mitch and RAA and to Bart and NSAI of making sure to frame the ELVIS Act in a way that people in the committees have a sense of like, oh, this is necessary moving forward, and will really be makes Tennessee a real shining light to the rest of the country of leading the way on these initiatives. So I appreciate that.
Thank you.
Yeah, I mean, it's incredibly impressive to pass this legislation unanimously. I think it does go to show that coalition building and that it did affect so many people. Music is so important to so many people. But I've also heard that as soon as it was passed, other states started looking at that. I wonder if y'all have been contacted. Are there, by other people or other states looking at enacting the similar legislation? Have you heard anything about that?
Well, right after Tennessee passed it, Kentucky was also sort of at the end of their legislative session. And they basically took the ELVIS Act and they passed it through their Senate, but they ran out of time in the House. I know that we've received inquiries from Texas, from Mississippi, from Virginia, New Jersey, and many others. I think it's important to point out that from a lobbying perspective, the tech industry and the motion picture industry have been fighting very, very hard against these bills. There finally was a compromise in Tennessee that frankly they had to live with, which should not have been controversial. Just to sort of explain the opposition, the motion picture studios, obviously use people's images and likenesses, and there are very legitimate uses, right? For example, you're making a documentary and you're showing a photograph of the person you're making a documentary about, and you may be truth-telling or storytelling, and you're not doing something that they necessarily would agree with or would want to be portrayed that way. But the First Amendment allows them to do that and to portray that and to tell that story. Well, the question is, are they able to do it with AI? Which I think, using someone's own DNA to tell a story that they don't like, I think is a little bit different actually than using just a photograph or past footage or something like that. But their position is they ought to be able to do that. And the Tennessee legislature said, that's fine as long as the First Amendment actually allows it. That shouldn't be controversial. If you're going beyond a use that the First Amendment allows, and you're using someone's DNA, you shouldn't be allowed to do it. But they wanted very broad categorical exclusions that said, even if the First Amendment doesn't protect the use, I want to be able to do it and no one can ever sue me. And Tennessee drew the line and said that is not going to be the case. Now, the good news about Tennessee is that Tennessee loves its musicians. It loves its creative community, and they were able to resist the tech community, which is very powerful. Very powerful.
And they're giants. They're the largest corporations in global history.
The recorded music industry in the United States is a $17 billion industry. I think one tech company's cash on hand is 5 times the entire revenue of the recorded music industry. And yet, without us, nothing's on their devices, right? And so there's this very important interdependent sort of system. But at any rate, in Tennessee, they basically said, thank you very much. We appreciate your opinion. We are going to put in guardrails to allow you to do constitutional uses, but we're not going to do more than that. And that was amazing. In other states, it's going to be harder. It's going to be harder because they don't have Tennessee's music community in all of those states to be able to fight back, where the legislators have an inherent understanding and instinct to protect them.
Is there more work to be done? Does this legislation do enough? Are there issues that you're still thinking about in terms of this technology at the state level? But also, is there any chance or any possibility of this being passed at a federal level? I know there's not a right to publicity at the federal level right now. So it's kind of like, what does the future look like for that?
That's a harder lift. One of my pet peeves that I'm sure the founders would roll over in their graves about is one U.S. senator can stop most legislation. And we've seen that happen. I'm going to let Mitch speak to bills being contemplated. This is a more artist-centric bill, the ELVIS Act. For songwriters, Dave is one of the leaders of the NSAI's task force on AI, and we've come up with a set of principles called the 4 Ps. The first is permission. Why should anything be able to take his human work product and learn from it with the express purpose to copy it and monetize it without his permission? And that's one of the arguments that Mitch has made in some lawsuits. Number 2, payment. If Dave gives his permission or the copyright owner does, we don't want some government statutory rate. We want to negotiate the payment. If this is used for film and TV and it's dun-dun-dun, that's a small payment. But if AI writes all the music for 4 seasons of a 10-episode Netflix series, they should be able to negotiate that. Proof is the third P. That may be the game. You've got to be able to prove it. We would love to see any generative AI software maintain a record in perpetuity that goes to the cloud. Will that happen? We'll see. The government's itching to get its hands around AI. That's never boded well for the music industry, but that seems to be a regulatory role for the government. And finally, penalties. And the reason I jumped in here, Mitch, is we are both working on some legislation that may be introduced next week that would at least allow, where it is feasible, for local courts to police this. But there is no federal legislation, and I'll turn to Mitch. That is a much harder lift, although it is the topic of discussion in Congress.
Yeah, and just to respond to what Cynthia just put into the chat on who protects us from electronic surveillance and mimicking, the privacy laws on electronic surveillance are complicated and I would argue ineffective. As everybody knows that, you know, AI in your phones and on your devices is certainly listening to everybody all the time for advertising and promotion purposes. But when it comes to mimicking, the ELVIS Act is actually broad enough to cover imitations and mimicking, which is a very interesting component. As far as federal laws, as Bart mentioned, there was a strategy to go to Tennessee, not just so that Tennessee could be the very first pioneer in protecting artists, which is totally great and appropriate. But there was no incentive for the tech or the movie communities to come to the table on federal legislation. And as Bart said, unless all sides have an incentive, like the Music Modernization Act, to be at the table, there is no table. So we had to create that incentive. And by passing the ELVIS Act, they are now vulnerable in Tennessee from a very good and broad law. So we sort of broke the glass, so to speak. And so now they do have an incentive to be at the table, because if there's federal legislation, the idea is that it would preempt state legislation where it overlaps. And this is also a global distribution system, right? As great as Tennessee is, it's very hard to enforce against a global distribution system in one state. And so we need to try to get federal legislation, but only if it's good enough and strong enough. And so there are 2 bills in the United States Senate. There's the No Fakes Act, which up to this point has been a discussion draft, and we believe is about to be introduced. We will see, the parties are all fighting to pull it their way. So we'll see how strong it is when it's introduced. And in the House, there's the No AI Fraud Act. So 2 bills focusing on establishing a federal right for people to stop their voices and images from being cloned and used without their permission. And we'll see what the exceptions are. What we can't have is exceptions that are so broad that they swallow the protection. What's the use of that? Then you get credit for being at the table and working out a right and saying people have a right, but they don't really have a right at all. So our job is collectively as a music community to fight to make sure that the protections are better than the exclusions. And that's going to be job number 1. And Bart's right. It's not going to go by unanimous consent. The only way it could possibly go this year, and I only think there's a small chance, I think it'll probably be next year, next session, that it's debated. But members of Congress are also suffering from voice cloning, right? In political campaigns, what they are doing to each other it's so shameful, taking your opponent's voice and putting it on something that they never said or never meant, misleading constituents. This is terrible stuff. And the child exploitation and sex trafficking and all these horrific uses. And so I do think that there is a small chance that they will attach it to a must-pass bill, because AI technology is moving so fast and the damage is so great that it might be a candidate for that. But I'd want to manage expectations and say Likely not, but there's a chance.
And Mitch said something, Jonathan, that I think I and David can speak to. I had not heard a fake song until February of 2023. The president of our association, Lee Miller, sent me a song, and I went, it was an old bread song being sung by Paul McCartney. I texted him. I didn't know McCartney did this. He goes, he didn't. But you could kind of tell. It was sort of rough. It was not there. At our last board meeting, one of our colleagues, Chris DiStefano, played a completely created AI song. It caused some panic. How this has evolved, Dave, in just over a year is scary.
Yeah, it definitely is. And also just what we're hearing now from Udio and these other companies is the worst that it will ever be. Tomorrow it will be better, and the next day it will be better than that. So yeah, if we're not moving quickly on legislation, the ground will really sink out from underneath us really fast on this. So I get what you're saying, Mitch, that it may be hard to be something that happens this season, but I would hope we at least start to create some sense of regulation around it before it gets out of our hands. Yeah.
Amen.
One other aspect of the ELVIS Act that we haven't talked about that I do want to touch on is how it impacts the estates of deceased individuals and the management of those estates for those artists. Could you talk a little bit about that, Mitch?
Sure. And this is really important. Tennessee was a pioneer even 50 years ago in, post-mortem protection, right? Because, the intent of the artist should carry out, since it's their music, their voice, their image, it should be carried out by the people who they decide should carry it out after their death. It should be the prerogative of their estates. Especially when it has commercial value. So unlike other states, Tennessee has a very strong post-mortem right to your image, to your likeness, and to your voice. And they do something novel, which they carried through into this AI legislation. They basically say it's the life of the person plus 10 years of protection after they die. But if the image, voice, or likeness of that person is in commercial use and continues to be in commercial use, the protection basically continues during the time that it is in commercial use. So, everybody gets the right to this legislation. Most people, 10 years after they die, their name and likeness isn't going to be used commercially, and the protection ends. But if you're Elvis, right? If you're Dolly Parton, and God, I hope she lives forever. But once that day happens, her voice will be used commercially for a very, very, very long time, maybe centuries. And basically, as long as it's being used, no one can just go ahead and take it without the estate's permission, or use it in a way that makes them that undermines their artistic integrity or intent without the estate's permission, unless they can show it hasn't been used commercially over the past 2 years. If it hasn't been used commercially over the past 2 years, then the protection dies. But if it has and it continues, the protection lives on. What a novel way, what a unique way to think about practically protecting people without overprotecting the whole system. So that's also what Senator Blackburn is proposing for the federal legislation, based on Tennessee, where she's from. And she's fighting to sort of keep that and to use it as a model, which is a great model.
Oh, I see a question has come in the chat. Does the Post-Mortem Act apply to imitations as the copyright law does?
In the ELVIS Act, it does. It applies to anything that the ELVIS Act protects. If there is federal legislation on this, I predict it will be limited to digital replicas. It will not include imitations. And I think it's important for us to distinguish between what we're calling imitations and things like musical interpolations or sound-alikes, right? We're not talking about, an artist getting up there and in a creative way using a vibrato that harkens back to Dolly, right? We're not talking about that. We're talking about somebody who is very purposefully trying to substitute for or live off the brand of an artist in an unfair way.
Well, looking ahead in terms of artists managing their licensing and their intellectual property, um, is there any place that that you're seeing or anticipating uh, where this might affect, licensing agreements and negotiation moving forward? Is this going to change the way that's negotiated? Are these rights now going to be a bigger negotiation point for artists?
For the major record companies, they just finished negotiating with SAG-AFTRA a collective bargaining agreement that includes provisions related to the licensing of name and likeness. Up until now, before AI, very typically an artist would license to a record company a limited use of name, image, and likeness for purpose of marketing and promoting the record that they are delivering. Today, managers have to think about a lot more. They have to think about brands and branding for an artist. They have to think about video and audio visual works, memes, and video games, the metaverse, and entertainment that goes, and promotion and marketing that goes well beyond the traditional forms. And so the ELVIS Act helps to secure those rights. I think that the record companies and the unions very quickly negotiated the ability for artists to give their consent and request and engagement when it comes to producing digital replicas, whether it's for branding or whether it's related to the underlying sound recording that they're delivering. So within the music world, I think the good news is there's been a coming together on the need for the voice and likeness of the artist, for that right to remain with the artist, and for the artist to consent and engage in those uses going forward. So it's a complicated world to be a manager today, but I think the music industry has stepped up in trying to figure that out. I wish the legislation would
well, a great illustration of that. I've known Randy Travis for 30 years, and Randy can't speak, as we all know. And he, following the 4 Ps, gave his permission, negotiated a payment using his own voice for AI to put out a new Randy Travis record. That's the right way to approach this. And David is part of a company called Milk and Honey. And it's a fantastic man named Lucas Keller that's just, he's one of my favorite people in the industry. And if I may, Jonathan, I would turn to David to point about another path to help this problem is in the marketplace. What's Milk and Honey doing, David?
There's some partners that we're working with to put out an AI program that's doing all of those 4 Ps that we've talked about. There's still a nervousness I have of as we move into any new technology, it's only a decade into it that we realize the full implications of what's involved with it. But I appreciate that in these early stages, it is creators, other songwriters and producers that are part of building this up, that they are really logging in everything that is ingested into the program. And as it's mapping out certain things for you, as you're giving it prompts to give us a drum and bass feel at 120 beats per minute that feels like this record or this artist, is really cataloging these were the things that were involved to build all of that stuff together. And as creators, I'm excited about the art that I have been a part of making, influencing other art moving down the road. So it's not like we want to hold all of it back. We just want to have a sense of control over the art that we've created in the first place. But if it's influencing all these other works around us, then that's great. My kids send me ridiculous memes of old Evanescence songs, and I love that, like, the art that I made is again finding its way in different parts of culture. So if it is creators that are part of that process with this new company that we're trying to develop, then there could be really exciting things that come with it. And also maybe even direct engagement from those creators as you are building up some new track and using all these other influences, that maybe you will have even a chance to connect to those creators in that process. So there are exciting things available to us. it seems like, especially with the tech companies, their incentive isn't about protecting intellectual property or looking towards those things. So if we can integrate those two pieces at the same time, then who knows, there could be really exciting things ahead.
All right. Well, it looks like we've got about 10 minutes left, so I'm going to open it up for Q&A. The way we're going to do Q&A, folks, is we're going to use the chat feature in Zoom, and I'm going to pull questions out of the chat to ask to our panelists. So if you have questions, you can add them to the chat feature, and I will try to get to as many of them as I can in the next 10 minutes. I will start with the first question that I see, which is from Thomas. It said, what keeps the industry from taking the masters of legacy artists, training those voices after the 2-year post-mortem rights, and creating new material without the estates?
Yeah, happy to take that, Thomas. So there's two different pieces here. One's a copyright piece, and one is a voice and likeness piece. On the copyright piece, the master recordings that a lot of tech companies are sort of copying without permission to train their models, that's the subject of the Suno and Udio suits that we just brought in Boston and New York. And I think your question is, could a record company or another owner, whether it's an artist owner, a venture capital owner, et cetera, of these master recordings, could they license the sound recording to train a model to produce new music? If they felt like the business model was useful and matched, their primary business, which is investing in human art, they could, just like they license streaming services as a distribution platform for that music. I don't think that the tech companies have given them a chance to consider whether or not that would be a good business model or not. I think they have to consider lots of things, like there's already 120,000 songs uploaded on worldwide distribution systems every day. What happens when there's 10 million a day, right? How much harder is it to break through? The first consideration has to be the artists that they've partnered with and invested in, and how to give them an audience and find them a market. And so any business model that they approve, I think, is going to have to go along with that mission. Mm-hmm. Then there's the voice and likeness side. And that's the artist's right to be able to license. If they license it to a record company to market and promote their record, if they license it to a brand, that right remains with the artist, whether it's under the ELVIS Act or any other right of publicity. So I hope that answers your question.
Thank you, Mitch. Another question in the chat: who protects you when you utilize social media, your ideas? Does this have any impact on social media usage? Does this legislation?
It does, and that's sort of that prong number 2 in the ELVIS Act that's so important, that allows you to go after the distributor. And it even uses the great words, making available. If you make available an unlawful name, image, or likeness that's done without the permission of the artist, then you're on the hook under the ELVIS Act. So right now, starting July 1st, we will be sending notices to Meta. We will be sending notices, to TikTok. And we will cite in the notice the ELVIS Act, and we will say, this is a meme or this is a viral video that uses the unauthorized voice of David Hodges. Take it down. It's not a copyright notice under the Digital Millennium Copyright Act. It's a voice and likeness notice that will now be under the ELVIS Act. That's what Tennessee has done for us. And there were several different social media companies. Out of the 6 major ones, 3 were taking them down before, and 3 were not, because they said the law wasn't clear. Well, the law is now clear. And so let's get it down. And we're hoping that all 6 of those giant companies will now adhere. And the other thing Tennessee did was they allowed the artists to empower us, their record label, because that's our job. We work for them. They empowered us to send the notices. So an artist or an artist manager can come to us and say, get this down. And we can use our apparatus and our tools that we've built for them, and we can send the notice on their behalf.
And in the last couple of answers, there's something also important to note. We have focused on advocacy in terms of legislation. I can't count the lawsuits that are out there, not just in the United States, but globally. We're heavily involved in the Anthropic suit. Typically, the courts or Congress, one is in the lead. So a lot of court decisions may impact how we maneuver towards solutions. How many of y'all involved in, Mitch? I can't even count the lawsuits.
A lot.
Yeah.
All right. Well, it looks like we've got about 5 minutes. So, to wrap us up, I'm going to ask each of you to, share your final thoughts. Anything that you think we haven't touched on that should be noted or is important to share with the audience. But we'll start with you, Mitch. Just final thoughts.
So just to answer Thomas's other question, for lawsuits, it does depend on where the defendant lives. It can be very difficult. That's one of the reasons why, as great as Tennessee is in doing this, it may be hard to sort of get jurisdiction over everybody in that particular state. So that definitely is an issue. I would just want to finally say, when Bart and I first approached the legislators and the governor in Tennessee about this, what was so amazing to me was how quickly they just said, absolutely. I mean, there wasn't even a hesitation. And the governor's office said, we're going to take up this bill as a governor's bill.
Governor himself.
The governor himself. This is too important. And the legislative leaders on both sides of the aisle in both houses immediately said, yes, we're going to do this. And, I've been lobbying for a very long time. When I first started, there was a sign in my office from my predecessor that said, please don't tell my mom I'm a lobbyist. She thinks that I play piano in a whorehouse. So I've been doing this. I've been doing this for a long time. I have never experienced what we experienced in Tennessee on this act, which was just this is Tennessee. Absolutely. No question. Despite the opposition, despite the nuance, despite the complications, and the industry just coming together and saying, yes, when we did this launch at Studio A on Music Row, and the governor was there, and the whole community just showed up, and the place was packed. And everybody said, tell me what to do, including David, including artists and other songwriters, including Natalie Grant and Matt Maher and the Christian community and the country community. I mean, it was incredible. So anyway, I know I'm sounding effusive here, but I've never experienced anything like that before. And to me, that is a hallmark of the community that exists in Tennessee. And, there have been a lot of controversial bills in Tennessee where I know the governor and the leaders have been on opposite sides. And it's been fairly divisive. And on this one, it was like that.
It was lovely and encouraging. My closing thought is personal. So there's no bigger Elvis fan than Bart Herbison. I was engaged at Graceland. His logo is TCB with a lightning bolt. I win every argument over who's the biggest Elvis fan because that is tattooed down my left shoulder here, and I'm proud of it. But my colleague Todd Dupler thought of the name, and I think that name was important.
He did.
I think the name really, when you talked about Elvis, you got the 4 Ps. And of course he's passed away, but people and I think it got global attention, but he came up with the name, and I will never get over that. I will never live that down. I will tell you, Mitch, I have told the Texas folks, I've come up with an acronym called the Willie Act for down there. So we'll see if that resonates.
I love it. Importantly, they asked the Elvis estate for permission to use his name in the act, which I thought was a very nice.
Very
apropos. The 4 Ps real quickly are permission, payment, proof, and penalty.
I guess in closing for me, I'm a songwriter. I'm a storyteller. I spend my days rhyming words together and trying to connect to what I think is like one of the oldest and most beautiful human traditions. We've been sitting around fireplaces telling stories and singing songs from the very beginning of it. I would rather not have to do any of this. Like this part of it feels like not like a distraction, but like something that songwriters aren't necessarily keenly prepared to be a part of. In that regard, I'm really, really grateful for Mitch and for RIAA. I'm really, really grateful for Bart and for NSAI and the work that they've done. The great gift that they give to us, and honestly give to those who love music, is getting all of this stuff, seeing down the road to see what problems are coming up, and allowing us songwriters and storytellers to do the thing that we do best. So I'm grateful to be part of this group and excited about what's ahead.
Thank you so much, David. Thank you, Bart. Thank you, Mitch. We appreciate you
Thank
being
you.
part of this conversation. It was incredibly informative. I know I learned a lot, and I hope the audience did as well. As I mentioned, everyone, we are going to share the recording of this next week. We'll send you a link. So if you missed any part of it, dropped off the call, you will have that chance to go back and not miss anything. In the meantime, please check the chat. There's a link to a survey. It'll take you about 2 minutes to complete it, but you can tell us how we did with this program. Let us know what we might offer in the future, topics that are of interest and of importance to the creative industries here in Tennessee. And with that, I just want to say thank you again to the Tennessee Entertainment Commission, to David, Mitch, and Bart, and to our audience today. Thank you to the state of Tennessee for passing this legislation, and everyone have a great weekend ahead. Thank you all.
Thank you.
Thank you.